Okay, so now we have panel one on whether the administrative law and private law in IP mix, and Professor Ruth Okediji will be our moderator. Just give me a second, I'm going to see if we can stop that sound.
If I could ask the panelists to come to the stage.
So I'm putting the sound on low so that singing doesn't
keep making noise. Thank you again so much to David for that keynote. I'm not sure the somberness in the room is a result of the seriousness with which David's keynote ended, or if people are still waking up. But hopefully it is the latter. Much to think about, and I hope over the course of the day we will be digesting both, I think, the tendency that our work and scholarship and research always feels to be lagging behind what's happening every day, and the more we resolve, the more there is to resolve. And so I think that this conference is timely, and we're all looking forward to working through some of these challenges and hopefully to setting some new questions that need to be grappled with and tackled quite urgently in the policy space. Our first panel is one composed of individuals that really need no introduction, and because of time, I will not be giving detailed introductions. Your conference brochure, for those of you who remember to pick one up, has all of the details of the backgrounds of this particular panel. I'm really pleased to be moderating, and we will not be going in the order that is listed in the program. Instead, I will be announcing the order and introducing our panelists. The panel session does administrative law and private law mix, and what we will be doing is exploring in at least general terms, setting the framework for the rest of the day, the role of administrative law in the intellectual property system and regime. We will begin with my colleague, Professor Todd Rakoff. We will then move on to our next speaker. I'm thinking, Todd, you will be sitting. Do all of you want to sit to give your talks, or do you? Everyone wants to sit? Okay, great. So I think we only have a few PowerPoint slides. Everybody else will be speaking from their notes. But our first speaker will be Todd Rakoff, who's a faculty member here at Harvard Law School. Then Kaylee Murray, who is a professor of law at Marquette University School of Law. And then she will be followed by the Honorable Scott Kieff, who is a professor at the George Washington University School of Law. And of course, as you all know, a former commissioner of the International Trade Commission. And last but not least, my dear friend, Arti, who's a professor of law at Duke University Law School. So, Todd, I'll hand over to you.
So the topic of this panel is, do administrative law and private law mix? And I thought I'd start off by saying it seems to me that if you're talking about patents, the question kind of answers itself, because right in the existence of a patent, you already have a mix between a private law and a public law entity. The private law side is pretty straightforward. Patents are bought, they're sold, they're traded, and I guess if you wanted to look at it jurisprudentially, you might say it's especially important that patents can be enforced by a lawsuit of A against B for damages in a sort of ordinary private law lawsuit. But at the same time, patents seem to me inextricably public. Look at it this way. If I go to a party at my neighbor's and I'm served a delicious cake, and I ask the neighbor for the recipe, and the neighbor says, no, that's been a family secret for generations. and challenged because I like to cook, I go home and I say, I can reverse engineer that cake. And after 4 or 5 times, I actually succeed in producing the cake, and I serve it at my next party. Nobody thinks that's wrong. That's perfectly permissible behavior in the society. And just to check my instincts on it, I asked my wife, and she thinks it's perfectly permissible too. If you look at it in terms of the ordinary mores of the society, if you look at it in terms of the fact that competition is privileged by the common law, patent is an inherently sovereign act. And it seems to me you can't get away from that, all right? So that it's right within the existence of a patent, the granting of a monopoly for years, that's a public act as well as traded and enforced and so forth as if it were a private law entity. So right within that, we have both things. So I would say my answer to administrative law and private law mix as regards to patent is yes. And what we're talking about is not the possibility of making it entirely private or entirely public, but we're talking about what's the balance between those two points of view. Now, I'm the ad law guy up here. I have a casebook here because I just got finished teaching a class in administrative law. So I'm going to talk about that a little bit from the ad law point of view. And I thought I would take as my topic maybe the most famous of all administrative law doctrines these days, the Chevron doctrine, about deference or not from the courts to, in this case, the PTO. And that's been written about. There was a very good symposium involving people who are here today that argued about that a couple of years ago. But that argument was largely a question of whether what the PTO does warrants Chevron deference, or at least what the PTAB does with its precedential decisions could warrant Chevron deference. And I wanted to look at it a little bit different way, which is what would happen if you got Chevron deference, or maybe more specifically, the choice between Chevron deference and the other kind of deference that's hanging around, which is called Skidmore deference. And for those of you who aren't ad law mavens, Chevron deference is the idea that a statute is ambiguous, then under circumstances where this doctrine applies, the agency gets to resolve the ambiguity as long as it does so reasonably. And Skidmore deference is maybe a more traditional idea that people who are experts ought to be listened to, and if the agency is expert, then within bounds of reasons, the courts ought to listen to what the agency has to say. In this world of administrative law, generally speaking, Chevron deference is thought to be the gold standard. And I think the articles that have been written about this have kind of assumed that if the PTO got Chevron deference, succeeded in getting Chevron deference, then it would truly have arrived as an administrative agency. But I want to at least raise a question about that, because it seems to me that Chevron deference and Skidmore deference are on a different wavelength as regards this balance between public and private law. So the theory of Chevron is that the agency has been granted the authority by Congress to resolve the ambiguity in a statute. And that inherently means that the agency can go this way or it can go that way. And in fact, the agency can first go this way and then a few years later go that way. Those are the facts of the Chevron case itself. And it was quite explicit in the reasoning of Justice Stevens in that case that he said the problem with what had happened in the court below was that it had adopted a, quote, static judicial definition of the statutory term, whereas the agency should be allowed to adopt a changing definition of the term. Now, Skidmore deference, by contrast, is based on the agency who has spent a long time with a problem, who has met it many times, who has lived with it, who has thought about it carefully. Under proper circumstances, the judges should defer to or listen to what the expert opinion is. But Skidmore is on the assumption that there's a right answer to what the statute means, and that the agency's view should be adopted as the right answer for what it means. Now, I'm translating that into what this topic of this panel is about. I'm going to say that Chevron deference is a more public law view, and Skidmore deference is a more private law view. All right? Chevron deference is about who has the authority to decide, and you get into Chevron by tracing lines of authority. Whereas Skidmore deference is more about there ought to be a fixed determination of what the statute means, and we have to decide whose view of that is going to ultimately be the fixed determination. So let me give you just an example to think about in terms of this. I don't want to take too much time, but if we think about the Myriad case 15 years or so ago, in that case, the Supreme Court held that mere isolation of a sequence of DNA that was shown to increase the risk of breast or cervical cancer, and therefore, by testing that sequence, you could make determinations about, for example, what kind of risk a woman has, and therefore what should be thought about in terms of whether there's mastectomy or not. That one could not patent that because one could not patent a naturally occurring sequence of DNA. Now, up to that point, the PTO had issued tens of thousands of patents for genetic material on the theory that isolation of a specific sequence of DNA plus demonstration of the usefulness of that isolation was patentable. And the PTA's view of this was not just accidental. It had been issued in guidelines that they had given to their patent examiners. And those guidelines had been adopted after a notice and comment process, so they'd been rather formally adopted. And at that time, the PTO's explanation was that discovery, which is included in the patent statute, and for that matter included in the constitutional definition of the patent authority, that discovery was okay so long as it was coupled with usefulness. That would equal patentability. And the Supreme Court refused to defer to this agency practice and instead said that if it was natural, it could not be patented. Now, there had been a lot of reliance on the PTO approach to this, both in terms of patents already granted and in terms of research going on to looking forward to patentable action in the future. And I suppose you'd say that reliance was now of less monetary value, all right? And so, all right, that's the price we pay for having a Supreme Court. But suppose you thought the court was wrong. Suppose you thought that the court should have taken the PTO's view and deferred to it, all right? There's two ways you could do that. If you go the Chevron route, you would say, we'll defer to the PTO because the word discovery is inherently a flexible term. It could mean something as little as stumbling across something, and it could mean something as serious as having spent years working at something. We'll let the PTO decide where on that spectrum of the meanings of discovery patentability should lie, and will sustain the PTO on that ground. Now, if instead you looked at it as a matter of Skidmore deference, you would say the PTO has done this thousands of times. They've worried about it. They've issued guidelines. They've thought about it in a notice and comment procedure. They've listened to objections and so forth. They're the experts on what it means. And so the meaning of discovery in the statute is what the PTO says it is. Now, the difference between those two approaches would be that if the court did it through Skidmore deference, that would be the answer for, I won't say forever, that would be the answer until either the Supreme Court reversed its own precedent or until Congress enacted a new standard, right? If instead you say Chevron deference, then you say, well, this PTO thinks that discovery means this, but 10 years from now with new appointees or a different understanding of the marketplace or whatever, that PTO can change it to another of the possible meanings of discovery. So Chevron deference would be taking an inherently, I'm going to call it public law or administrative law view of the problem. That it's a changing problem over time and that the agency should be constantly looking at things and thinking about whether it should change its view, just as the Environmental Protection Agency did in the actual Chevron case. Whereas the Skidmore case would be taking the view that we should establish what I'm going to call the private law view, a fixed meaning of the statute against which people can plan and against which patents are validated or not, and not changeable until there's a much bigger, not just administrative agency change in the law. So that's a long way of saying the PTO maybe doesn't want Chevron deference. Maybe they'd be better off with Skidmore deference. At least this PTO could then lock its views into place for the long haul. I understand I'm arguing a technical, not so technical, but well, not so technical to me, point of administrative law, but so just let me finish with my broader point, which is, it seems to me that in thinking about how administrative law plays into the patent system, we should be thinking about it as a more or less involvement of the administrative agencies down the road, rather than a just sort of, it is one or it is the other, and that's the end of the question.
Okay. So it's always nice to follow up someone you absolutely agree with 100%. And so I'm like, whoa. Yay! I've been arguing for Skidmore deference for a while and thinking about the relationship of Skidmore deference to the wide variety of different things that the office does. So today I wanted to start off thinking in here in a relatively short talk about a theme that I think is important to understand as we think about private rights and public administration in patent law. That is, patent law is unruly. Like, it doesn't work the way we want to every time. And that when we are in a moment, I think, in patent law where we either want to place patent law into a neat private law bin, right? Or we want to place patent law in a neat administrative law bin. But I urge us to reject that particular binary conception. And so I basically just said what he said, right? And so when we think through this set of questions, I think it may be helpful to think about patent administrative law in as a longer-term project than we typically think of it as, and that views of legislative, executive, or how legislative, executive, or judicial actors can regulate a patent have changed over time. And I think it's important to think through that patent law administration has a longer history than we like to admit, and that history has, I think, real impact on the types of conflicts that we're seeing today. So the first place I want to start, the first moment I want to start at is at Section 3 of the Patent Act of 1790. And I don't know if you have your Patent Acts of 1790s available right now, so I'm going to read it to you. It be further enacted, nobody actually reads Section 3, upon patent application of any person to the Secretary of State for a copy of the application of any person to the Secretary of the State. The Secretary of State has a responsibility to issue, the language is shall, right, issue such specification, and also had the ability had the permission to issue similar models or make, right? And the applicant had to pay for it, but the Secretary had a mandatory duty to provide information to an interested public. And for me, I've always been relatively intrigued by this provision, right? It's not an extension of the patentee's right? This has nothing to do with what the patentee wants, nor, right, is it an outline necessarily of what the Secretary's powers are. If we look at Section 1 of the Patent Act of 1790, that's really where we really see how the Secretary's power is articulated in terms of issuing the patents. But it is a public right? It is the right of the public to actually receive information about the patent. And that it is also, I think, important to note that it's mandatory, right? That the Secretary go ahead and issue this information to the interested public as long as they can pay for it. So I want to sort of highlight 3 important points about this particular moment in patent law. Right? First, it suggests the way in which patent executive administration in the United States differed from England, right? So, reading the current oil states briefing, we talked a lot about England and not enough, I think, about the United States, the actual country you're in, right? And I think both Mario Bajoli and Zarina Khan have suggested that what makes U.S. patent law distinct from its very start was this mechanism of providing information to an interested public. And so Section 3 really, I think, embodies that particular notion that there's always been a type of public administration that we don't pay that much attention to, that is that the idea, at least at the early constitutional era, that patent law not only served the patentee, but it serves to create a public that could circulate patents and moreover, that could use patents to create an innovative structure. And so, again, one of the things that I think is also important about Section 3 is that this impulse to make patent information public and permit the public to have access has continued in patent law. It continued in 1836. If you look at the Act, at that point, the office referenced libraries, that the patent office had to keep a library, right? And so again, what we're seeing here is a type of public right in an interested public that can view and see patents and use patents. And I think it's very important then to think about what that means and what view of regulation that embodies. And I think the first way, I think it's important to note, I see it as part of what I call a well-ordered culture, that is, patent law works like copyright, and to create a culture that listens to and understands and communicates about the goods in question. And, it was always lovely to see Justice Breyer sort of begin to reference this both in his dissents in Eldridge and other different forum. And I think that it's something that we should uncover because it tells us a different story about what public regulation meant, that we had a type of public regulation very early on that attempted to do something that we don't think a lot about, but has important implications for what kind of regulator we see the Patent Office to be. And again, I think it's important, right, because it suggests that the public law of patents is more complicated than we think, and that, moreover, it's been there since the very beginning. The second time, I'm going to say this until we get this new, the second sort of moment in time I want to pay attention to, Commissioner Kapelos might not love this part. But the second set of materials I want to pay attention to are between 1870 and 1890, at least 14 state legislatures, right, passed a series of laws that attempted to control patents, right? And the specific terms was it required patentees, assignees, or peddlers to either acquire a license for sale of a patent project or register the patent in the local land registry, okay? and this was a fairly consistent set of laws, and it was an attempt to control sort of overreach in the agricultural area of a number of patent owners. And so this set of regulations, I think, highlights something that we should also pay attention to, that when we think about private law, we are very often, right, think of private law as, well, it protects the right of the property owners. But I think it's also very important to assert that private law sees a patent as a property right, but also sees regulation that is embodied in common law, statutory law, and constitutional law as imposing obligations on property owners, and those obligations serve as the basis for regulations. You are obligated, right, to sign the local land registry. You are obligated, right, to ensure that your patent is being properly sold by the relevant individuals. And this is really, right, and states in this way are regulating through their police power, right? And this was a common understood, I think, mode of regulation from the late 1890s through the 1930s. And they deliberately treat patents as property, right? Not necessarily to empower patentees, but rather to permit state and local entities to claim that they could exercise police power over the license sales of patented products. Now, I think this language of regulation is important, first of all, because it links, once again, patent law to broader theories of regulatory use. And secondly, I think it's also important to note that this language of obligation that started in state legislators made its way into how we see constitutional patent law, in particular, the famous bargain, right? This is really where we actually see the language of property and contract law. The Supreme Court basically went through a 20-year debate over this, right, between 1890 and 1920, right? And out of that, out of the motion pictures case, we see really the first reference to the bargain, the quid pro quo bargain between the patentee and the government. And I think we need to pay attention to this language of obligation in private law because it helps us to understand how, at least at the very early stage of modern administrative law, the early 1900s, or 1900 to 1920, people were struggling with and thinking about what's the most appropriate way to regulate, and they turned to private law to find the metaphors of public regulation that were appropriate in any given situation. Now, I think, first of all, right, its history is useful because it suggests to us that we need to pay attention to scale, right, in understanding patent administrative law. Very often we talk about it as only being federal when it can also be state, and it can be premised on a very different set of powers than we understand within the context of federal administrative law. And secondly, I think it breaks the claim that simply by making private law choices that one is able to avoid regulation, right? Oh, well, you're a property owner. Then you're not regulated, right? No, that doesn't work, right? Private law actually provides a series of substantive themes that suggest that regulation is completely appropriate, and they use private law metaphors to advance that, right? And I was rereading, as part of the assignment that Henry gave us for this panel, I was rereading Oren Kerr's early work in this area where he says, oh, well, you don't need administrative law because private law will serve as a function. And I think what I would respond to Oren is like, yeah, you could say that, but you could also say that private law provides a sustainable set of regulatory devices, right, that are important, and that you can't just say by choosing private law, we decide not to choose regulation because private law has its own regulatory mechanisms, and that's a very important way of understanding themes in our patent law. And again, it suggests things that people find tricky about patent law, patent exhaustion doctrine, patent misuse. These are all actually expressions of the obligations that we place on property owners, the patent owners in this area. So private law doesn't solve your regulation problem, right? Private law just provides different types of mechanisms for regulation. And then finally, I want to talk about thinking about patent administration over time, right? Again, this whole sort of talk has been an exercise of that, but I want to end with where we are right now in patent administrative law, and my favorite new provision of the AAA, Section 122E, right, which requires third parties to be able to submit comments during the review of a patent. Now, why is my favorite Well, I think it reveals the current incoherency of how we think about public patent administrative, right? And here, Richard, again, homework, thanks, Henry. Richard Pierce's great work and sort of talking about, well, there was a traditional model of private adjudication in the early 1900s to 1920s that was replaced by the expert model, the technocratic model in the 1930s and 40s, and finally we end in a participatory model, right, that suggests that interest groups, that we legitimize agency behavior through interest group participation. I think that this is a really important frame for how we see debates over public administrative currently. The first reason why is because I think the Patent Act embraces all three, right? So we, in essence, have an incoherent act, right? It, on one hand, provides for lots of private regulation. On the other hand, it provides for some expert administration, and then it ends, though, overlaying this sort of participatory politics model. And I think one of the reasons why we're still debating patent administration so actively is because different authors are referring to different models when they see patent law, right? And I think that is a problem. If we're not on the same page about what patent administration is, we can't even begin to sort of get to, I think, some of the murkier issues that come to us from administrative law. Like, I've always found Chevron to be really interesting because do we offer deference to the agency because they were actually engaging in expert behavior, or are we offering deference to the agency in Chevron because they've undertaken certain types of things like notice and comment rulemaking that get interested third parties involved, right? We can't solve the murkiness of Chevron in patent law until we decide which patent public administration we're talking about. And that's not even, you know, in my pet project, adding what I call the fourth model, right? That the patent law is really about public information, public circulation, and we have to pay attention to the ways in which the USPTO shapes that behavior. So I'm going to end here because I think it's a really good place to start and move into Scott's presentation.
What a pleasure to follow such great, two sets of great talks. And I guess what I would add, if I may, in direct answer to the question, lay my cards on the table, I think admin law and private law mix well. I take it we mean mix well. I think they mix well, only to the extent the power of ideas beats the power of all of this kind of administrative apparatus. And so I think I think you've each made great points, but at least for me, I have taken greater comfort in the power of ideas. So by that I mean, maybe this is antiquated, but wouldn't it be nice if a reviewing court were to say, agency, you're acting ultra vires. You're just totally out of this. You're unconstitutional in some big, bold way. Or, agency, you may not notice this, so sorry. This is like what you say to your best friend when you're at the hot dog stand. There's mustard on your chin, right? You say to the agency, dear agency, there is just a clear, logical inconsistency within your record or your opinion. It seems to me courts are at their best when they otherwise restrain themselves to a greater degree, to essentially some form of outrage constraint. Point out what's outrageous. Let the agencies that have, for both of you, the Skidmore-esque engagement, at least force them to do the same. Force them to explain why exactly their experience has found that crossing the street when the light is red generally helps you avoid getting hit by a car, and crossing the street when the light is green for you, the pedestrian, vice versa. Just elucidate, elaborate. So I say all of this. This was the guy who nominated me, hugging the guy who did one of my favorite songs. So I left the government. I left halfway through my term. I said goodbye. And I said goodbye because I think surrendering power is a feature, not a flaw, and explaining ideas is its own form of power. Because, like Ferris on his day off, you can have a lot of different people looking in different directions and encourage them to talk to each other about what they're seeing. The agency I left is not a New Deal agency. Its current iteration is a New Deal agency, but it's a Civil War agency. And it's worth just remembering that here at Harvard, because, of course, the first problem Hamilton had to solve as Treasury Secretary was he had to finance a really expensive federal government. And we did it for 100 years with taxes on imports, not with an income tax. And taxes on imports cause a practical financing dynamic problem, which is the more you charge for stuff, the less you get of it. So the federal government had to try to figure out the dynamic economics problem. That was what Hamilton did with this report on manufacturers on the left. I should say, tried to do. That state of the art in economics and data analysis at that time was just frankly not that good. But two things happened over that 100 years. Economics as a science got way better. And the other thing that happened was economics is endogenous to politics in a system where the administrative state is responsive to politics. And while I think we all really, really wish the Civil War had been fought over slavery only, like we should have killed each other for that. I think we all agree with that. It just turns out that wasn't enough. It was the politics of tariffs that was the second biggest driver. And the chairman of the economics department at Harvard at the time was a fellow named Frank Taussig. And he sketched out a model for an agency that would harness that intense political disagreement the North and the South had over tariffs, harness that intensity as a way to coerce cooperation, collaboration, and the exchange of ideas. And the way he did it is he set up an independent agency. Taussig left Harvard, ended up becoming the first commissioner and chair of what was the predecessor to the ITC. In those days, it was called the Tariff Commission. But the ITC is structured not like the rest of the executive branch. And the key differences are two. You can summarize them really quickly. The two are inside the building, you have a plurality of decision makers. So there were 6 of us, presidentially nominated, Senate-confirmed commissioners with 9-year staggered terms and a chairmanship required by statute to rotate among the 6, person and party, every 2 years. So what does that do? That makes it a political big thing of inertia. It's hard to swing. It's hard to move. If when my team has the chair, your team gets office space that's 1 square foot smaller than my team's, well, that's fine. In 23 months, in the wintertime, my office is in Nome, Alaska, and in the summertime, it's in Miami outside, right? Just that little incentive, that little incentive to poke each other in the eye, except not, because if you do, they're going to poke you back harder. That intense incentive changes behavior, entire behavior in the building. Outside the building, the parties who come before the commission are like the courts on this side, in that the parties are not arguing over abstract, hypothetical notions of balancing of the type that David was describing. Balanced discussions are very hard because each side in a neutral, naked, balanced discussion claims the other one's off balanced. But when patent validity, patent infringement, patent remedies, and antitrust are all argued at the same time, when they're all in issue at the same time, each side of the V, each advocate, has a selfish incentive not to engage in hyperbole. So as patent lawyers always teach patent students, the stronger a claim is, the weaker it is. The more I argue that my patent covers the world on offense, the more I'm likely to capture prior art on defense. So I have a very selfish incentive to instead make much more neutral, moderate, modest, less hyperbolic arguments. Not because I'm a nicer guy, but because I have self-restraint incentives, because I know all 4 topics are on the table at the same time. That's happening at the courts and at the ITC. That's not happening at DOJ, Antitrust Division, FTC, or PTO. It's not happening. They're highly restrictive in what they're looking at one time. And the beauty of being laser focused is you can focus, but the risk of being laser focused is you lose perspective. So what I think agencies within a government and across governments can be at their best when they express ideas to each other explicitly, so that they can then say to each other what they like or don't like about them, or what's wrong or right about them, what is illogical or inconsistent or incoherent about them. I think that's law at its best. It is, I think, not because we at the ITC, my colleagues and I, were somehow super awesome, but rather that we forced ourselves to listen to each other, that we happened to emerge with a perspective at the IP antitrust interface that evolved to be surprisingly similar to the European approach and the Huawei ZTE decision. And it's worth noticing that while both of those approaches were evolving out of parts of governments that were forcing collaboration, you had the more administrative, more power-focused parts of both the European government and the US government being much more hyperbolic. Now, look, I get it. You watch television today, it's kind of hard not to see. You look at Brexit, you look at the comprehensive economic trade agreement between Canada and the European Union, and the holdup in early October by the Wallonian Parliament, right? This is a small part of Belgium that voted no on this transatlantic trade deal. And of course, the 2016 election with its results in TPP and TTIP. Regardless of who you wanted to win and how all of that played out, it is pretty spicy on television. What I think is noticeable, though, is a few things. One, even in Europe, while you had this fear of disintegration, a week or two later, the Wallonian Parliament swapped its vote, got to yes, the EU got to yes, the North Atlantic had calm. It's worth noticing that while the British were hooking up an outboard motor to their island and trying to scooch away from Europe, it kind of didn't really work out that way, because in parallel, the British were leading the effort to create the Unified Patents Court, which shows a lot of cooperation among European member states, which reveals both a capacity and a preference for cooperating with each other, not through the EU. Right? The EU is a governmental entity, an intergovernmental entity. It's not a geographic thing. Europe is a geographic thing. Europe is a cultural thing. The European member states have been cooperating with each other since the coal and steel agreements, the atomic energy agreements. They're still cooperating with each other. If you go on the web and look up the Unified Patents Court, you'll find there are courthouses set up all around Europe. They're hiring, by the way, if you want a job, now's the time to apply. You too can be a judge. This may not work. This may not be good. But it does reveal that the Europeans, including the British, are still cooperating with each other while exit's happening. So, okay, we see this on television. We see, the finger. I think that in a bunch of these areas, IP, antitrust, false advertising, whether you look at the vitamin C case that's going before the Supreme Court next month. I have a paper finally no longer embargoed about the ITC decision last month, the decision published so my paper can publish. But the basic idea in all of these is to point out that for intellectual property, for antitrust, for false advertising, for a range of interactions between businesses. I think the core of private law. Yeah, look, businesses can lobby. They get a real shot in the arm of caffeine when they lobby, because you can get high tariffs, you can get other big, bold actions out of the government. But the government doesn't have to explain very much when it does that. It just does it. And as a result, it tends to respond very much to politics, and politics shift. And so a company who's delighted to have the caffeine can often find that it has a tiger by the tail when politics shift. So I think it's in companies' private best interests to consider alternatives to that kind of highbrow power of the state. And the alternative, I think, is agencies and courts adjudicating more mundane facts where the adversarial process tests the truth or falsity of the facts, and the areas of law are much less responsive to these broad political preferences. So falsity is a good one. It's also, in the antitrust setting, worth noticing, there's broad consensus. China has a Sherman Act analog. The OECD embraces what we talk about as Sherman 1. We have Sherman 1. There are broad shared notions of how you can really mess up a market through coordination. And it is worth noticing that at the core of the vitamin C case and the steel cases are not just arguments about low pricing. They're arguments that are highly analogous to the concerns Senator Warren and others here at Harvard have expressed for years about bid rigging and market rigging. Think about LIBOR, right? Think about the notion that at every nook and cranny, every bid-ask up and down the value chain in a particular part of the market, a single nation state can set the price. That's a very, very powerful thing. That's the allegation. I don't know whether that's true. I take no position on whether it's true. Someone's going to have to prove that stuff. But what is worth noticing is that in the Second Circuit vitamin C case and in last month's ITC steel case, those were the allegations. The allegations were not low pricing, for which one side argues, yay, I get to buy stuff for less money, and the other side argues, boo us, we can't charge as much. That's not what I think is really the core threat. It's the core disruptive power of a very, very large actor, in this case a nation state, to disrupt markets' private ordering. And I think markets can respond to that, and private actors can respond to that by litigating over ordinary facts, and then let the chips fall where they may, prove it or not. So I think that agencies, for me, the theory about what makes for an independent hearing officer or administrative law judge, what makes for a good record in an adversarial proceeding, what happens when one senior government official says, I know that we scheduled to hear the argument right now, but golly gee, I'm just so sorry, will you please hold? I'll get back to you. And then a year later, when you were all ready to make your argument, suddenly, you know, the tables have changed and so forth. I think that's government at its worst, when you're using these really weird, seemingly benign, seemingly mundane, down in the weed power struggles to basically prevent a discussion about ideas so that you can assert prerogative. And I think government at its best when instead you have what we all know, for example, in the federal rules, to be a relatively straightforward set of ways of fighting over facts. Thanks.
Thank you. So great. It's wonderful to follow all these really very enlightening presentations. And I would say, Scott, that I didn't really have a title for my presentation, but now it will be The Power of Ideas Through the Administrative Apparatus. So let me talk about why I think, and by the way, I'm basically winging it at this point because I think it'll be much more interesting for me to respond to some of the ideas that were put forward than to have my pre-canned presentation, which, and it turns out that all the other three speakers spoke about things that I had no idea they were going to speak about, so it's great to be able to respond to them. So I think the administrative apparatus is there in order, as I would suggest my title, my reframed title indicates, in order to, at its best, in order to make sure that ideas are front and center, and in particular facts. I wrote an article, now 15 years ago, on how I think facts are central to the patent system, and the problem with our entire apparatus is that we've put expertise in the PTO with respect to fact, and then we pay no attention to it afterwards, or at least oftentimes the Supreme Court does not with respect to facts. So let me then also speak to the question that is the subject of the panel, which is, do admin law and private law mix? I think, as the other speakers have said, it's complicated. Patents aren't public or private. They're a little bit of both. And I think in particular with respect to patents, one needs to distinguish, and this is where I will start a little bit with my canned remarks, between validity and infringement and other issues. So I'm just going to focus on validity because I think that's where patents probably have their most public character. And that public character has increased over time, I think, in the main. That said, I think the recent Supreme Court decisions in this area are really quite a mess, and I have no idea, as a consequence, either what's going to happen in oil states or what's going to, or more generally, how the Supreme Court would think of a proposal like Skidmore deference, and so more on that in a minute. I can't sing that tune quite yet because I have a fear that what the Supreme Court would think about if they use Skidmore deference would be, well, that means that all our old decisions from the 19th century still count. And because, of course, the patent system predates the administrative state, and so all those decisions are still in play. That relates to an article that I think Professor Rakoff may have been referring to, where I talk about the value, perhaps, of Chevron deference, but the very small likelihood that the Supreme Court would approve of it in the context of the PTO because they are so enamored of what their view of what they think is stare decisis in this area. Okay, so the complications are many with respect to patent validity. I do think that as a consequence of what we've already discussed, in particular the America Invents Act, we've moved to a much more public notion of patent validity. I'm not sure that it's necessarily a participatory notion. I think that the third-party observation stuff is probably a little more of a faddish thing that was put in. Not to be derogatory about it, but I think that I'm not sure that participatory notion is really ultimately, as a realist matter, going to yield that much power or have that much power. But I do think that certainly the adversarial piece of it is huge. Although I should note, and this is one thing that I think is important to note, even before the AIA, the inter partes re-exam process did have a fairly significant adversarial role for the third party. So we've been public for a while now, I think at least since 1999, through the role of the third party adversary in the inter partes re-examination process. But with the AIA, it's clear that there was a very strong sense, and Director Kapos talked about this, not only of bad patent quality, but also that there needed to be a more administrative public role in addressing the issue of patent quality. In other words, the courts weren't doing it. So the courts, the argument went, and this is where I think, we academics may have played a small role. So there was a set of prominent reports from the national academies, from the FTC, bunch of articles by people like Rob Murgis on why courts can't do this. And the reason is that the court system is premised on a plaintiff versus defendant interaction. It doesn't integrate the collective idea. And a patent challenge is inherently a collective action problem. And that's why you need the administrative state, because if you have a collective action problem, courts ain't going to solve it. And that, I think, is the key intellectual insight behind the AIA. I do think that the FTC, the national academies, those intellectual inputs into the AIA early on ultimately bore fruition in the creation of a real collective process for challenging patents. So not only can you, in the context of filing AIA petitions, have joinder, but the petitions are a lot cheaper, and so the collective action problem is substantially reduced. Okay, so I think the AIA made patent validity more public, but it wasn't simply in the adjudicatory frame. There was also substantial regulatory power given to the agency, and the Kozo versus Lee case in 2016 made that clear. It said that the regulatory power given to the agency under the AIA is not procedural or substantive, it's just power. It'll be interesting to see how the Supreme Court ends up dealing with that case in oil states, because if a lot of what was said in Kozo seems to point to a very, very public law model of the patent validity determination, at least. One of the reasons for all of this, in addition to the collective action problem, is simply scale. So this is the other piece that I want to bring up. And I thank James Smith for this insight. It caused me to go back and look at some numbers. A while ago, Chief Judge Smith, former Chief Judge Smith, pointed out that Congress hasn't done anything in terms of growing the Article III courts. So I went back and looked at some numbers. From the year 2000 to 2018, the number of district court judges has grown by precisely 12, 651 to 663. During that time, the number of patents in force, and this is, I just checked with my RA on this, today it's 2,776,820. That's a 270% increase from 2000. So 2% versus 270%. That's huge. And I think the courts are simply not going to expand to deal with this problem. And as a consequence, we need a very public administrative adjudicatory apparatus. Okay, so I just have a few minutes. I want to make sure we leave time for questions. So to the question of Chevron versus Skidmore. So this is, I think, a really interesting question. And to be clear, we're talking only about Chevron versus Skidmore on the question of core patentability determinations like novelty and non-obviousness and the like. The PTO already gets Chevron on its rulemakings that are not core patentability determinations. So Kozo was a Chevron case. They got Chevron on their Kozo, or on their rulemaking on broadest reasonable interpretation. So to be clear, this is just 101, 102, 103, 112. So now I do think that there is, so Professor Rakoff and Professor Murray do have a really valid point with respect to Skidmore and the reliance interest that Skidmore promotes more strongly than Chevron. We all know that Chevron has the possible downside of being subject to the political winds, and so as a consequence, administrative agencies can shift positions. But the problem is, as I indicated earlier, if we adopt Skidmore in the context of these 101, 102, 103 decisions, how would that have turned out in Myriad? I don't know. I don't know, because they had all those 19th century cases that said according to them anyway, that they had to rule the way they did. And the court, even all of the members of the court, in cases from Kappos versus Hyatt to Microsoft versus I4I versus and Kimball versus Marvel, so this isn't an ideological thing at all, have really focused on their own old cases. And that's what really matters to them. So I don't know how Skidmore would fit into that. I really don't. Of course, their own old cases, even though stare decisis is supposed to promote reliance interests, when you go back to the 19th century, well, you may be upsetting the apple cart a little bit when you do that. And it turns out, certainly the Section 101 jurisprudence has completely upset the apple cart, even though they would say it's just stare decisis. So much so that Jonathan Mazur has an article coming out in the Stanford Law Review saying that maybe the Supreme Court should just, when it rules, should rule prospectively only, because they upset reliance interests so much in the name of promoting stare decisis. So I don't know. I don't know whether Skidmore would do the trick. I see the argument for it, but I don't know. And what I do worry about at the end of the day is that we do have a very incoherent Supreme Court, and maybe as a lead into the next panel, I'm not sure how they'll even think about the oil states issue, given their views that, on the one hand, in cases like Quozo, we're talking about a very public determination of patent validity. On the other hand, in cases like Kappos versus Hyatt and Kimball versus Marvel, and the 101 cases, all these 19th century Supreme Court cases are what matters. So I guess TBD. Thank you.
Thank you so much to our panelists. That was a rich and dizzying array of both historical antecedents and also the complexity of the administrative law and intellectual property interface. We have a few minutes for questions, and I have taken the first moderator's prerogative of the day, and that is to extend our time in the Q&A session should we need to. So are there any questions for our panelists? Are there mics for? Oh, great. I can't see who that is. I'm going to put on my glasses. John, is that you? All right. Yes, please. I think because we're being recorded for volume, we need. You need the exercise.
All right, I'll skip lunch. So my question is I think all the panelists talked about Chevron a little bit or mentioned it. It began with Professor Rakoff mentioning it. And so I want to ask, if you use Chevron on the core patentability issues, what happens if the agency, says, let's say, things are patentable under Section 101 or 103, and then 10 years later, halfway through the patent term of some of the patents that they said are patentable, they say that's no longer patentable. It seems like then the property rights go away. And you can take the reverse problem. If they were rejecting applications, you've got some applications that were rejected, and maybe the people just gave up, but other people may be persisting to try to get their things, and suddenly the agency switches and says, oh, this is patentable. And then I think there's going to be at least some degree of unfairness where people who said, well, we took your word for it, and we didn't continue to fight you, but now a new administration has changed directions. It seems kind of unfair. So I guess the core question is, does the Chevron framework really fit with something that is property to some degree? And I'm not sure if there's any case where Chevron has ever been applied where it can sort of wipe out property rights. So that's the question about how Chevron works with property, and I gave some hypotheticals to sort of probe that question. Thank you.
So If it was the PTO does not have rulemaking authority over core patentability issues, but if it did do that through rulemaking, let's say in 2007 it was proposed that the PTO be given core rulemaking authority over core patentability issues, and there was a huge pushback for some of the reasons you articulate, John. But my question is, rules are prospective only, are they not? So why would you be upsetting property rights if you said that prospectively we will not grant patents in this space?
So I guess it depends on how you view prospectivity in that area. Whether you'd say, certainly if you take the applications, you'd say, well, or just say there's AIA proceedings continuing. You'd say that they'd have to apply the rules under which the patents were originally granted, because that's not the way I think Chevron would normally work. If there were an agency of proceedings, you'd say, well, we're going to apply, what the new administration's position is.
So I think looking at it as with the big category property maybe is too big, because lots of what agencies do change the value of existing property. I mean, sort of every environmental regulation does that. And nobody thinks that has to be compensated unless it gets to the point of being a taking, and that there's a whole argument about that. So I think it's more the particularities of the patent system that raise the problem. In sort of regulatory adjudication, when a rule is changed in a, let's say, FTC proceeding or FCC proceeding or something like that, it is incumbent upon the agency to think about the retroactive effect against the party being regulated. And so you'll see decisions that say this was illegal, but it's a sufficient surprise that it was illegal that we're going to say it was illegal, but we're not going to levy the fine or something like that. But that only helps the party directly in front of the thing, and you're raising the question of what it does to all the other similarly situated parties, and I don't have a good answer to that.
I will just, the trial lawyer in me just has to offer up one nugget of juicy plum, which is, of course, the Windstar cases that are contract-like rather than property-like, which when the government makes a sufficiently powerful statement to the savings and loan industry, we want you to be taken over by large banks, we want the large banks to do this, we're going to adjust capital requirements so that they can hold what essentially were otherwise illiquid savings and loans and still satisfy capital requirements. That was what the government did to try to resolve the banking crisis 2 banking crises ago. It then changed its mind midway through, and Windstar was one of the savings and loans that brought suit. In fact, won. It originally sounded a lot like a takings case, but it was ultimately in the Supreme Court, I think, embraced as essentially an old equitable restitution argument, as some version of a head fake. You told us you told us to go one way. You can't now yank us back in this other direction. But again, those are the individual private parties who were yanked around.
I want to ask you to actually introduce yourselves before you ask this question. I assume everybody knew who John was. So,
Is he next to me?
Mr. Chow.
Stephen Chow from Boston. I wanted to raise the issue, it's a little bit off target, but it does relate to property and to public participation, which is the concern that I've had over many years about how it really requires a company to have 9 figures in annual revenues to litigate, and even 8 figures in annual revenues to do the IPR process, either defending or asserting it. And I'm looking back at the older days, and I note with Commissioner Kieff, when eBay came out, one of us said, who took the P out of IP? Now, this is a different view of property, sort of Calabrese idea, that the ability to have an injunction was what allowed people to trade. And in fact, smaller companies often relied on that the fear of an injunction might force people to a negotiating table. And that's gone to some extent, unless you're actually competing. So I was just curious whether any of this is played into the academic debate on this issue.
Would like to go. Scott?
Again, the trial lawyer screams out for litigation financing as the solution to that. And of course, there are pluses and minuses to it, but it is not factually true to say that people who have causes of action for which the facts are compelling and the law is stable and predictable, it is incorrect to say that those people, in fact, don't find their way able to bring lawsuits. They do all the time. That's what key TAM cases are all about. They're frequently litigation financing heavy. A lot of securities litigation is litigation financing heavy. We have seen litigation financing in the IP space. There are wrinkles to that, and we should be very aware of those, but it also does allow people to get to court. We've seen the same in civil rights litigation.
Okay.
Melissa Wasserman, the University of Texas. So I wanted to ask, one thing I think that sometimes gets lost in the debate, at least when we're talking with deference doctrines, is the idea that PTAB can be appealed directly to the Fed Circuit on the record or to a district court where you kind of get a trial de novo. And at least to me, some of the Supreme Court jurisprudence could be read as maybe administrative law principles don't always apply as strongly in that context, and I didn't know if you guys had thoughts on whether that should matter.
Just connecting the existence of the Federal Circuit with the Chevron issue, one of the best explanations for the Chevron doctrine in general, that is to say, as applied to other agencies, is that offered by Peter Strauss of Columbia, which is that if you're thinking about the country as a whole, if the agency is the national player and the circuit courts of appeals are just regional players, and if you say to the circuit courts of appeal, just decide things the way you want to decide them, straight up on the merits, then you get different law in California from what you get in Massachusetts, where if you say defer to the agency, you get the agency rule everywhere. So that's one of the justifications of Chevron that disappears in this context with the existence of the specialized court, which has the national jurisdiction.
Scott?
Just on your point about the collateral or the appeal to a district court, yeah, I think that the Kapos versus Hyatt case really thought of the whole issue in non-administrative law terms, notwithstanding the fact that the SG had vehemently argued for thinking about it in administrative law terms, and I think the whole Section 145 regime, and this is the subject of a great paper I think you know by Michael Grieve, is a holdover from the 19th century where, we didn't really have appellate model review of agency action in the way we have now. So I think he uses a metaphor from Milan Kundera, and I'm not going to remember it, but in any event, yeah, so I think that's absolutely right.
Okay. Scott, last word on this?
I just, whether I'm a private party or whether I'm inside the government, handling that question, my incentives, I think, are the same, which are build a factual record and explain my legal reasoning. And I think that if I do both of those things, regardless of the precise lens the reviewing court or Congress or the body politic applies, I think I've empowered the audience I wanted to reach to at least push back if they don't like what the intervening entities do. And I think the intervening entities are at their best responding to that pushback or anticipating that pushback if they, in turn, explain why the lab notebook really said June, not January, or why the legal reasoning is flawed. And so I think that these doctrines of prerogative and deference and review often have the effect of masking both at the lower and upper levels power. And I think stripping away the power and replacing it with the power of ideas is better for everybody. If what you like is, for those who are public law leaning, more democracy, and for those who are private law leaning, more predictability.
All right. I'm going to take both questions because our time is not just up, but I'm beginning to push back that. So last two questions.
I'm Kumiko Kitaka. I'm from GW. Thank you for the great talk. I learned a lot, and I learned about Skidmore and corrective actions and expertise in PDO. But my question is about Myriad and 101 issue. I might be wrong, but I think 101 is more about antitrust oriented issue rather than 101, 102, or 103. I'm not sure this understanding is correct, but as Mr. Kapos made a comment, I think USPDO is very codified in deciding on 102 and 103, but 101 is basically judicially created doctrine. So I'm not sure 101 is very appropriate question for the USPDO to handle. I know the agency has issued several guidelines on it, and we are referring to it, but I'm not sure how much it's influential.
Thank you. Last question.
Do you want my name first?
Yes, please.
Joachim Martillo, MinRisk Software. And my question is about sovereign granting letters patent. And I don't quite see how that makes it a public law issue. I mean, we're on territory that was granted letters patent to the Massachusetts Bay Company. And no one argues that this is public law, this is private law. Why does that become public law with regard to patents to knowledge, territories of knowledge?
Well, if there was a question to end the panel with, it would be that one. So I'm going to ask the panelists to please address the 101, 102 issue first, and then so that we can all have a last word, or you can all have a last word on this question, which I suspect will, if not care is not taken, will take us into the red zone, which Patrick has given me the evil eye already. So,
in a private law respecting regard, I yield all of my time to my colleague to my left.
Okay.
So I actually don't hate the Section 101 myriad cases. I know that's like controversial words in patent law right now to actually say, hey, it's not that bad, guys. And the reason why is I think it's important to understand I think it is expression in many respects of, I think, this obligation language in the 19th century cases. And I think to the degree that we begin to think about what does the Supreme Court's deployment of constitutional law norms in this area, I think it's actually important to actually think through their reasoning and why they're thinking about how patent law has to address its sort of private law moment. So I actually I'm not a hater. The second point, I think, is that I would argue that, and this is one of the arguments I made in my talk specifically, that this question of sovereign granting patent law, I think we need to stop using that language when we talk about the law of the United States and its early Republican era. I think that what was happening in acts like the Patent Act of 1790 and the Patent Act of 1832 was we were attempting to move away from necessarily seeing the governmental grant as sovereign, we were moving towards seeing the governmental grant as democratic and public in origin. And I think that's very important to note, that we've moved away from this question of sovereignty in the way that it would have been understood in 1790, and we've moved towards, I think, a different democratic public patent law.
Todd? Last word?
I don't know the history the way you do, so I'm going to leave the history alone. I just think that it is worth thinking about for those, if you look at patent law from the outside, how different it looks from lots of other property law. Lots of property law is just kind of a continuation of the customs and understandings of the society into a formal regime. When my students come in and sit in a classroom the first day, and if I don't assign seats, they just choose a seat, they don't think they have a property right in that seat. By the time the third day comes and they sit in that seat, they think they have the right to tell other people, this is my seat. And other people will acknowledge that as a claim. And when I then pass out a seating chart, I'm just making formalized law out of what was the custom prior to it. And it seems to me that whatever we call it, you just have to recognize that granting someone a monopoly for years to do something doesn't have that quality to it. It's something superimposed and different from what would be taken as the custom of the community.
Arti, last words.
Sure. So I'll just make a couple of points. The first is that I would be remiss if I didn't channel all of my colleagues at Duke to point out that, of course, we're talking about information here. And so information has very different characteristics from land, and let's make that clear. Secondly, I do think that the whole question of patent common law, which we haven't used that term yet, but there's a lot of common law of patents, which is what, of course, the Supreme Court relies upon all the time. How we deal with that within the administrative state, I think, is really complicated. And that's why I think the Skidmore issue and the 101 issue raised by the questioner is an interesting one, because it is the case that the Supreme Court thinks that this common law is perfectly legitimate, almost interestingly, like they've been delegated the authority by the Congress to make that common law, because as we know, federal common law is a very rare beast, and yet we have it in the patent system.
I think we will be returning to many of these themes over the course of this day, and hopefully you'll engage in additional conversation with the panelists. Let's just say thank you to them for opening us up such magnificently.